This is a quick recap of the tort of negligence. 5 minutes. Let's go.
Negligence is the tort that allows a person who was injured or whose property was damaged through the negligent action of another to sue that person for compensation. To succeed with a claim in negligence, the burden of proof is on the claimant to prove that the defendant owed the claimant a duty of care. Second, that the defendant breached that duty. Third, that the defendant's breach caused the claimant's damage or injury. In short, the claimant has to prove on the part of the defendant duty of care, breach, and causation. Let's start with the first element, the duty of care. The concept comes from the neighbour principle formulated in Donoghue versus Stevenson by Lord Atkin. We now have a large body of case law giving us precedents for established duty of care categories. There are also several statutes imposing a duty of care. In the very rare instances where there is no precedent, so in other words, no established duty of care category, the court has to be convinced by the claimant to recognize a new duty of care category. They do this by following the three-stage test set out in the case of Caparo Industries versus Dickman. The court asks, 1. Was the damage reasonably foreseeable? 2. Was there a relationship of proximity between the defendant and the claimant? 3. Is it fair, just, and reasonable in all of the circumstances to impose a new duty of care? If the answer to all three of these questions is yes, the court recognizes a new duty of care category. Once the claimant has proven that the defendant owed her a duty of care, the next step is to prove that this duty has been breached by the defendant. The courts do this by using a legal construct called the reasonable man test. The standard of the reasonable man was first established in the case of Blythe versus the proprietors of the Birmingham Waterworks in 1856. In practice, the court compares the defendant's conduct to what we would expect a fictional person called the reasonable man would do under similar circumstances. If the defendant was less careful than the reasonable man or the reasonable person, then the defendant has breached their duty of care. This is an objective test, meaning that the specific characteristics of the defendant are usually not taken into account. For example, in the case of Nettleship versus Weston, a learner driver was judged against the standard expected of any average driver. Once duty of care and breach of that duty of care were established, the claimant then needs to prove that this breach of duty caused their damages or their damage. Lawyers refer to this as the requirement of causation, the requirement that the claimant has to prove that there is a direct link between the defendant's breach of their duty and the claimant's resulting damage. Causation is measured in two ways. First, factual causation or causation in fact. Here, the question is whether the defendant's breach was the actual factual cause of the claimant's loss, or whether it was caused by something else. We use the so-called but-for test formulated by Lord Denning in Cork versus Kirby McLean. Lord Denning said, if the damage would not have happened but for the particular fault, then that fault is the cause of the damage. If it would have happened just the same, fault or no fault, the fault is not the cause of the damage. Secondly, causation in law or legal causation. In addition, the claimant must prove that the damage is not too remote from the fact that caused it. The courts use the test that was formulated in the case of the Wagon Mound, namely that the defendant will only be liable if the damage was a reasonably foreseeable consequence of the breach of duty. As with all torts, we have to keep in mind that even if the claimant succeeds in proving their case, the defendant may still raise a successful defence. The main defences against a claim in negligence are consent, contributory negligence, and to a much lesser degree, illegality.
If you found this recording useful, also check out my other 5-minute videos for other torts and other areas of law. If you want more detail, check out my long-form lectures and other resources on my YouTube channel.